Yes. Yes, absolutely.
I need to know.
Okay, so I've got to figure out how to prop this thing up.
Hopefully you watch his leg. Okay, his name is Artie.
Artie.
Our judges
Okay, guys. Have you all noticed Artie Dent? Reese Dent? Yeah.
Adam, can I get you to turn that chair and face it like however it needs to face? I'm going to try to actually lean this phone up against
society.
Evan, can I get you to grab your water bottle? I'm sorry, I'm going to knock this table over. Oops, sorry. There we go. I'm going to try to prop my phone up on this. Hang on, I got to admit her. Where is she? Okay, admit. Please work. So Evan, you're going to have to kind of watch how you move around. Hopefully that she won't fall over. Is that okay? Is she there?
Hi, Alyssa.
I hear you. I can't see you. How do I do this? Yay! Okay. You're getting propped up on something, so hopefully you won't fall over and you'll be able to.
You can see my hand. Sus.
Wow.
Roberta, let her see. Okay, if she falls over, somebody pick her up. All right. Sorry. Okay, I have a scrambled scripture, but it's on my phone. My phone is being used, so hopefully I'll get to it later and I can share it later. All right, so my exordium for mock trial is I want to take the time to point out a couple of things that I have noticed, and I want to, just keep you informed. So, all of your direct examination questions and the cross-examination questions for all of the witnesses on Google Docs, right? So they were pink, purple, and blue. And so what I did after I ordered them per your instructions is I went in and I took those paper clip groups that you gave me and I made them all the same color. And then the ones that weren't in a paper clip group are all the same color, but so I'm going to show it to you. I've got one of them here. So you will notice that you kind of can't tell who's who anymore. That's on purpose. So this is Zilius's direct examination questions. And you'll notice I had paper clip 2 strips together, right? I assigned them both number 1. I changed them both to red. I changed the font. And I took your names off of them. But they're all still there, but you can't tell who wrote what, okay? But that tells you, whoever it is dealing with Zilius's witness statement, that these are identical and you need to figure out which one you're going to use, fuse them together, add one, take one away, whatever you're going to do, right? So then you'll notice that the second question wasn't in a paperclip group, right? It's in black ink. But the font, again, it's all the same font, same style, same everything. I took the person's name off of it, if it had one. And so you kind of, I'm sure when you read through them, you're going to, oh, okay, there's one. That's fine. But for the most part, once roles are assigned this afternoon,
oh boy,
you will you'll notice you're kind of going to be in little mini teams. And that's kind of surrounding which witness statement you're working with. So these mini teams will need to go in and just figure out, okay, number 3, it was like 5 questions that were paper clipped together. They're all green. And we've got to figure out how to make this all one, narrow this down, figure out which one we want to use as opposed to the others. Does that make sense? Is that clear as mud? So you will notice that they're all like this. Like all of them. So I just rotated out colors. When I would get to a paperclip group, I would just rotate out colors. Anything in black was not in a paperclip group. I want to point something out just so you know that I noticed this while I was following your instructions. So I noticed that in this particular group, question number 4, the answers, it's a paperclip group, right? So 2 questions, the answers deal with I fixed up a house, right? And then you have question 5, and then question 6, and then I get down to question 7, and I went, oh, hold up. This answer deals with I fixed up a house. Do you get what I'm saying? So it's like I fixed up a house, and then question, I fixed up a house. So I'm noticing that these need to be further refined. Does that make sense? Like the reason why, and I mean, it's there, it's kind of throughout all of them a little bit, but this is just an example that I wanted to point this out. So in number 4 and in number 5 for this group, there is a similar or identical answer to these in number 7. And then I come down to number 10, and the answer is, I dropped out of college to fix up a house. So are you seeing how, like, they're, like, these are in the order you want them asked. And so if you keep going, I fixed up a house, I fixed up a house, you're gonna get asked an answer, right? You're gonna get an objection. So that's, I just wanted to let you know that I'm noticing that there's some similarities, not even in just the paperclip groups, but in questions that weren't in a paperclip group, and then in other paperclip groups. They're kind of alike. And so you're gonna want, once you get roles assigned, what I would highly recommend is you get with your mini team, and that's up to your parent. It can be Zoom, it can be in person, however you guys need to do it, and get together and further refine your questions around the particular witness statement that you have that you're going to be working with. Does that make sense? Okay, so just know it's getting there. It's just not quite there yet, and I wanted to make sure that you're at least aware of it, because you guys need to start practicing, and you can't practice until you have your questions the way they need to be to tell your story. Does that make sense?
Yes.
So the questions need to be refined, organized, narrowed down before you start practicing. There's no sense in you starting to practice when you have some repeats. Does that help at all? Okay. So I've let your parents know already. So then I've vomited on group me this weekend, and so they got, like, they don't have this, but they have what I'm seeing. It will be in my newsletter. So hopefully they get repeat information to where they remember to check in with you, and also start facilitating your mini meeting. And I told parents that it doesn't matter to me whether you get together in mini groups or if they host like this big thing with all of you and y'all just round robin it out. You know what I'm saying? So that really, it starts, this is the beginning of me going, here you go, I'm out. Does that make sense? Okay. All right, so I did want to touch on that. Let me put that with my stuff. All right, so any charts for evidence? Let me make sure I am tracking with my schedule. I did that. Good. All right. So I wasn't quite sure. This has happened differently every year as to how I address this. And it can be lots of different things in different ways. So on this page, we have catalog page for fight and fill, the crane rental attachment, the artistic rendering, and the construction site drawing. On this one,
How is it so nicely drawn?
because I did it.
Yes.
That's a different.
That's it? You only have 5 points in that?
All right, so has everybody got their Annie charts with them? One, two, three. We got, ooh, I can combine Adam and Elizabeth and Willis and Della, y'all will be, ooh, yeah, that works. So team 1 and 4, since we.
Oh,
Yeah.
that one. I was thinking there's 10 people in the class and one person on 180, but then there'd be no squad.
Yeah,
Yeah.
so team 1 and 4,
almost a genius.
I will let you hang out on, we'll do, Hello Petrified and Field, like that sheet on over there. Team 2 can be up here and team 3 can be on that end.
Are we ready?
Oh,
We have the most
they
work
might
ever,
speak,
like-
I don't know, they might be authorized. But anything that you collaborate on what you found for your
We have the
evidence.
most work ever.
Hopefully we right.
Wait, what is it?
Wait, what do we do?
Got it?
What are we doing?
Oh,
We have the most work out of everybody.
Yes.
What are you doing?
Only teachers are involved.
Is it?
My senior.
You really cannot have Sharpie.
Okay, so if we're gonna draw, guys, can you hear me? If we're gonna draw on people, I'm gonna take the Sharpie.
Thank you, that's a great rule.
All right, so, go ahead and transfer your Annie chart info onto the collaborated class Annie.
Okay.
Not necessarily, I mean, like, I might get you around. So it might be like, take 5 minutes and then I'll switch you to take 5 minutes.
Already can't spell.
Okay,
You get it. Got all that from there.
all right,
I got you was saying
so.
like no longer move
So,
aside.
okay.
Like, oh, use this red.
Hey,
color,
guys,
it's
Can everybody hear me?
Yes.
I'm gonna rotate you out every few minutes.
Alien machine.
Because this one's only got 2 on it. And the
Come
other
on,
one's
that's
got
down.
1.
We need you.
So,
Like just wait here.
Can I?
Oh,
is there-
boy.
yes, I'm sorry.
You want me to log in?
Yeah.
I just kind of felt like I already said
Okay.
that.
You have your answers.
Oh,
Well, if you just,
That's just
you're fine. But do you roughly
yeah.
remember?
Exercising curious.
So like, we, can you be our writer?
Yeah, right.
So like, use the. Okay, I was, thanks.
So we should.
Care
Yeah.
Writing.
He's inferior. Right.
Writing's not gonna be. Where? But we're in the.
Thank you.
I don't think I have a fee.
What did you have? Jail things, I believe.
Yes, it does have a C. I got it right.
Interesting, let's do that first. Purchase for $1. Yeah, sure.
Egg. Oh, I know so.
That's
Side.
good.
Oh, is it?
Ooh.
Okay, yeah. Let me see if I can find it.
Oh, because they can put them in jail. Ugly cannot be in jail.
Oh, wait, this is,
Who got air?
wait, what?
Yeah, prosecution is putting them
Will
in
this
jail.
one work? I don't know.
I put through mine.
Also an interesting.
Yeah, that's what I
Like
assumed as well. Well.
That works?
Oh, no.
It'll-
Oh, no.
Ugly. Yeah, I have a lot of
Make it
experience, so I'm
contract.
gonna move over here, guys.
No, I messed up. No.
And other ones.
Okay, you can find it. It's like I bring every Sharpie out.
And only 2 of them actually work.
I might have another one that'll work.
Contract.
Oh, it was stuff.
Don't put
I
that.
think the first one was the best.
Guys, I have another Sharpie that
No
works.
E.
You have a Sharpie that works?
No,
Okay,
This
you want to
works.
that up? Okay. Just give it to Della and not me.
No E. Yeah.
Sorry, evidence.
Okay,
I
in
guess
defense,
you-
it's completely legal.
It's the
Defense,
one I
completely
I'm
legal.
not.
Defense.
I'm
I
guessing,
wonder,
I
can I
made a
send
guess.
this text on my phone while that Zoom is running? I'm guessing it's gonna be. He's supposed to text me when he pulls it.
I mean, that's how I
Sorry,
spell it.
guys, I wasted.
Okay, Robert, do this.
Really?
L,
Oh my goodness, Adam.
L after, yep, L-Y. No E, L-Y. Legal. Affirmative.
Just I just give you all of them because I don't know
Big
which ones
bonus,
were.
if Pam finished quickly.
Okay. Ah, okay.
What is that, Taylor?
Okay. I can't.
Wait.
Excuse me.
Oh, yeah.
They never actually said that.
They never actually said. They never actually said that, they had a difference in life. They just said lack of common sense. That's not what. But it's not when they're on travel. They're not on travel like common sense. They're on travel for disregarding human life.
Yeah.
So it'd be on. So I would say it would be on the defense.
Yeah.
Definitely.
Right, being five.
It helps because they might have been, yes.
Air.
Smiley face. Okay. Affirmative.
You can start making that.
Affirmative.
Big and circle.
10 billion.
Are people to the point where they need to rotate? Okay, I'll let you work. I mean, like.
$10 billion.
Did I have my phone?
Wait, we have to do all.
Yeah. 10 billion
I'm
less.
sorry.
I did hear a ding.
Okay, you don't mind, I'm gonna run and check the door, make sure it's not the attorney.
No, it's done before deadline. It's done after deadline.
I don't know. Oh, yeah. So much.
Never mind.
Oh,
I had a really
Marty and Grace
Oh,
said
I don't
lots,
let
like
anything
Romeo
like
and Juliet.
And they actually.
The dog in my story is named Artie.
Artie, was this your last name, Jim?
And the horse is named Grace.
Oh, you're-
Oh,
Was that
Her
first?
name's Gracie. Ow, my knee is hurt now.
Okay, next.
Okay, guys, our attorney, Mr. Crane, is here, you can take a seat, and we'll pick back up when he is finished. Go ahead and come on in, you will want a spiral notebook of some type of blank paper, and something to take notes with. Just so you know, I'm running a Zoom call of a student out, so hopefully she will be able to see and hear, and that is recorded. Thank you so much for
Thank
meeting
you.
us. Guys, this is Mr. Josh Kearney. He is a criminal attorney in Murfreesboro, correct? So he is here to talk to you about courtroom etiquette, protocol, what to wear, where to stand, how to act, all the things, okay? So I'll let him present. If you have questions, save them for the end, and hopefully he'll have just a few minutes to answer any questions you might have. I went ahead and sent him some. So, thank you so much.
No problem. How you going?
Good.
That's good.
Yeah. I mean, it's good to have you done with math next, so.
That's all right.
Math is fun.
And y'all are doing mock trial?
Yes.
First time doing it? Nervous? What does this mean?
Really? A little nervous.
Like you don't really know yet, or you're not nervous?
Really?
Really?
A little nervous, but excited.
Okay. I've got a list of questions. I can run through them, but before I do that, what are there specific things that one of you want to know?
It can't be case materials.
Yeah, don't give me case material. Let's don't cheat. Nothing?
You have to have something.
I talk a lot, like, I don't know.
Okay, well, let's do this. Let's just run through some questions. And as it generates questions in your mind, then you can say, hey, wait a minute, let's delve into that a little deeper, okay? First question that was sent to me is, what do I wear? What do you think you wear? Okay, a suit. If you're what?
Attorney.
If you're an attorney, okay. What about your witnesses? What do your witnesses wear? Go ahead.
Maybe like clothes that kind of suit what you are, like if you're.
Yeah.
Yeah.
Yeah, right on, man. The witnesses, think about mock trial like a play, okay? Because honestly, that's all practicing law in a courtroom really is. It's just that you do it with really high stakes, okay? It's acting to some degree. Now, when I say acting, I don't mean you're kind of a fake, fictitious type thing. But when you act on a stage, what are you basically doing? Anybody in here act? Anybody ever done stage productions? What are you doing?
Reacting.
You're what?
Reacting.
No, not really. What are you doing when you act?
You're becoming the character that you're trying to play.
For what purpose?
To act like them.
Okay, but why?
For entertainment.
Oh, entertainment for who?
The audience.
The audience. Okay. Nobody gets on a stage and acts in an empty playhouse, right? You practice that way, but you practice that way because there's going to come a day where the seats are filled, and what are you wanting to do?
Please the audience.
Please the audience, right? Okay. So the context may be different. You want the people after that play to go home and go, oh my goodness, man, y'all have to go see this play, right? When you go into a courtroom, you're doing the same thing. You're presenting material, though it's factual as opposed to fictional. And you're trying to move a group of people. It's just that your audience now is a jury, not a bunch of people watching a play, right? It's the same thing. So because of that, what's your name, Blue?
Evan.
Evan. Okay, so when Evan says, well, you dress based on the role. Exactly. Exactly. So let's just say hypothetically, I'm going to trial and I have a police officer that's going to testify. What might that police officer wear? His uniform. That's one option. Anybody else? Oh, come on, guys. This is CC.
I see.
All right, my kids have done CC. I know that y'all function way up here. Okay, so a suit. All right, now we got options, right? So I'm calling a police officer to the witness stand. He can either wear a uniform or a suit. How do I make that decision? Any ideas?
Based on what's in like the witness statement or what's in the book, what you would have to play as.
Okay, that's possible. Okay, but think about this. Go back to that play analogy, right? If you're in a play, do you dress the way you dress when you go to CC? Why not?
Because you're
being that character.
You're being that character, but it's more than just being that character, right? Because I'm Josh Crane. Okay, here's what you see today, right? This is like my least favorite stuff to wear. All right. If you saw me on a normal day, it would be blue jeans and boots and a t-shirt and a ball cap. Okay. It's the same guy, right? But what I need to convey is different. If I had come in here today dressed the way that I like to dress, you would still listen to what I say, but you would receive it a little bit differently because the stage doesn't look the same. Okay. So if you have a police officer, for example, maybe it's a uniform. Maybe I do a uniform if you're like, say, a road officer, a police officer that patrols all the time, and that's your normal look. But what if you're a detective? If you're a detective, maybe it's, hey, I want you in khakis and a blazer. I want you to look professional, but I don't want you to look intimidating, right? When a police officer walks in a courtroom and he's got his duty belt on, he's got his gun, his taser, badge, and microphone, and he can barely sit down in the witness chair because of all that stuff. If you're presenting to somebody, that might actually be intimidating. And I don't want him to be intimidating. I want him to be relatable. Okay. So think about that when you think about what to wear. Attorneys, as a general rule, my opinion is you always wear a suit. If you're a lady, you wear either a pantsuit or skirt and jacket. Okay. It's business professional. All right. Witnesses, and just generally, you have to know what your witness is and how you want them to present, and let them present based on that character. Okay. So let's go to the opposite extreme. I've got a lay witness, right? Not an expert. I've just got a general witness. I've got Billy Bob. Billy Bob's a farmer that worked across the street when the shooting went down. He jumped off his tractor and was like, oh man, look right there. That's bad, right? I don't want Billy Bob coming to court in a suit and tie. Because Billy Bob's going to walk in there like this. He's going to, swear to tell the truth. Sit there. Well, here's what I seen the other day. I was milking my cows. And the jury's going to be like, My brain has to put these two things together. Okay. Now, I don't necessarily want Billy Bob maybe in overalls, but I gotta find that middle ground, right? Questions about that? Oh, this is gonna be easy, crowd. Go
How
ahead.
come we don't have Billy Bob in our?
I don't know.
I wanted to be Billy Bob.
I didn't write yours this year. Okay, next question I had was, what if I lose my place during opening statement, questioning, closing argument? I don't know. What do you do? What do you think you do?
Maybe pause to correct your thoughts.
That's a good starting point. Yeah, absolutely. One of the consistent problems that you'll see with mock trial, and if you continue to do mock trial through high school and college, and then maybe if you unfortunately go to law school, which we can have a whole other discussion on why I don't think you need to do that. One of the things, any kind of public speaking that you do, you are going to run encounter with the time where something happens. You get distracted. And it's just enough to knock you off of where you wanted to go. Okay. When I used to coach mock trial, this is what I used to tell my students all the time. All the time. You do not want to be ill prepared. You do not want to be ill prepared. What does that mean?
Unprepared, like not enough practice.
Ah, there we go. Not enough practice. Why? Why does that matter?
Because if you have more practice, it'll just come more naturally. You can have better presentation skills.
Exactly.
Mess up with me as appealing to the jury.
Okay. And here's the thing. For today, when I came in today, how much of what I'm telling you do you think I scripted out before I came in? How much? Give me a percentage. Give me something.
80%.
80%?
50%?
50%?
60%.
60%. So far, we're all over at least 50, right? Anybody else? 0%. 0%. Okay, but this is important. Why did I prepare 0% for what I'm going to say? I've got questions, but why did I prepare 0%?
Because you have knowledge and stuff.
You're right. There you go. Because I do this all the time. Okay, so because I do it all the time, I don't have to go, oh my goodness, what's my script? I've got to remember this. Okay, we've moved past that. You need to move past that. All right. If you are in a position where you're a lawyer or you're a witness or you're the bailiff, all right, we're gonna talk about bailiffs because don't neglect your bailiff. Okay, if you're one of those and you show up and you're still like, okay, ready for my first question. Okay, what's your name? My name is George Franklin. That is not convincing, right? And everybody in here can get past that, but you have to be completely prepared. You have to have complete knowledge of your material. And the only way you do that is you go over it and over it, over it, over it. And you need to do the same thing that I do. I've been doing trials for 17 years, okay? You do the same thing that I do. You get in your bedroom, you get in an office somewhere, and you're totally by yourself, and you pace the floor back and forth, and you do your presentation to nobody. So that when you go into the courtroom, oh, I've done this. I know where I'm going. So that if you lose your place, that really doesn't matter. Because losing your place matters. Like, for example, the play. In a play, you're delivering from what? What do they give you when you're part of a play? A script. They give you a script, right? It's important for you to stick to the script, right? This will be maybe fly right over all of your heads, but one day it'll make sense. Okay, in the script, you go, I want the truth. And the person says, what? You can't handle the truth. Okay, that's the script. You're not on a script. You're telling a story, right? What would it be like? How many of you like to read? What do you like to read? What do you like to read?
I just like to read normal historical fiction books.
Historical fiction. Give me an example.
There's a book called The Cry of Egypt, and it's when the Israelites were in Egypt and they had to go free.
Okay. I'm gonna give you 30 seconds. Tell me about the book.
There's a girl named Jera, and she's pleading to God, and she really needs help because
her mother is crippled and they're working so hard and they keep getting hurt. And then Moses comes into Egypt and and at first they're all excited, and then he makes the Pharaoh mad at them and they keep having to work harder. And so she keeps praying they can be free.
Okay. What'd you notice when she told me about that?
She had knowledge of the book.
She had knowledge of it. Here's what I noticed. I noticed when I was talking to her and I was telling her, this is what I'm gonna do, I'm gonna give you 30 seconds, she was looking at me. Okay? The minute she started telling me about it, what happened? She stopped looking at me. It's not a critique. It's a point. She stopped looking at me. She started doing this. What is she doing when she's doing this? She's remembering. She's recalling information. We do that with our eyes. We recall information with her. Why am I here? Right? Okay. But here's the other thing that if you pay attention, you notice. How many times did she say, how many times did she do that? None. Because she knows it. Right? Now, what would that have sounded like if she had the book sitting in front of her and I said, hey, just pick a passage and read it to me? Would it sound the same? No. Okay. That's where we want to get. And if you know your material front, back, up, down, east, west, north, if you know it completely, you don't even have to worry about what if I lose my place, because you're telling a story and you know what your story is. We good? Questions? You're making this too easy. All right, my next question. What if I submit the wrong witness statement for the witness to read from or the wrong piece of evidence? I don't know. Seems like a big deal, doesn't it? It's not, right? It's not. So let's say that this is a piece of evidence, right? And he's my witness. And so he's up there and I'm like, oh man, I got this down, you know. I say, well, after George threw the rock, were you able to collect the rock? And he says what?
No.
Come on, I got the rock in my hand, right?
Yes.
Yes, I goes, okay. And so what do? I go, okay, can you please identify that? And then I go, oh, snap. That's not the rock. That's the report, right? I'm holding the rock. What did I just do? Okay, why? I'm sorry if I may. Can you identify that for me, please?
It is round, has a crack in it.
There you go. And what is that? Is that the rock that you collected?
Yes.
Good, thank you. You see, it's not a big deal. It feels like a big deal because in your mind, you feel like it's a mistake and I'm not supposed to make mistakes. Okay? You will not be perfect in mock trial. But part of the way that you perform in mock trial is not just, can I execute everything flawlessly? It's how do I handle the issues that are unexpected? And mock trial by design is supposed to have some unexpected stuff in it. Okay? So if you mess up, so to speak, if you hand the wrong statement to the wrong witness, first of all, witnesses, you need to be ready. Okay? If I'm your witness and you're the attorney and you say, I'm going to hand you a statement, could you please identify it, right? And so you walk up and you hand it to me and I look at it and I say, because I'm a good witness and I've worked with you, I go, respectfully, this is not my statement. You go, oh, I'm sorry about that. You put it back in your notebook. Here you go. You laugh it off, you move on. Okay? Questions? Okay. When can an attorney move freely about the court and how do they ask to do so? All right, this is really, really important. So if you're gonna take a note on this one. I don't know who your judges are gonna be or how they're gonna set up, but this goes to general decorum within a courtroom. Anything you want to do outside of the normal parameters of just, I'm gonna talk to my witness, I'm gonna do my thing, ask the judge, okay? So for example, if I was an attorney in mock trial, before the trial got started, sometimes, maybe not always, but sometimes your judge will say, are there any preliminary matters before we get started? Okay, and even if your judge doesn't do that, maybe you stand up and you say, Judge, before we get started, there are a couple of preliminary matters if we can take them up. Okay, look at your rules, figure it out. But what you simply do is you say, Your Honor, during the course of questioning, may we move freely about the courtroom? And your judge, it's your judge's responsibility to either say, yes, you may, or no, I want you to stand behind the podium, or you may, but I don't want you to get beyond this point with the jury or something like that, okay? So how you know how much movement you're allowed, you ask the judge how much leeway they're gonna give you. Okay? And then only take that leeway. Questions about that? That kind of dovetails into the next one. When do attorneys have to stand behind the podium? The judge tells you to. Okay? Now, will y'all present this in front of like parents that serve as a jury?
Yes.
Okay. Okay, so let me give you this little tidbit, which may help you in some things. All right, let's say, for example, this wall over here is where my jury is. Okay? Let's say the judge is over there and the podium is right here. All right, watch this. Let's say I am direct examination. So I'm questioning my own witness, right? I don't care which side you're on. Okay? So here's what I'm gonna do. Where's my jury at? They're over here. Okay? Where's my podium at? It's over here. You see what he's doing right here? Don't move. You see what he's doing right here? What's he doing?
Looking at you.
He's looking at me, which means he's not looking where? At the jury. So here's what I'm gonna do. Mr. Jones, can you tell the jury what happened on April 7th, 2022? Now where's he looking? He's looking at the jury, okay? Witnesses, if your attorney gets stuck at the podium, which can happen, look that way. There you go. You look at the jury, okay? Now I'm gonna cross-examine him, all right? I'm gonna cross-examine him. I'm standing over here. And I want him focused on me because now he's not really talking to them, he's talking to me, okay? So I would stay behind the podium depending on where the podium is in the courtroom and where my jury is, separate and apart from where the judge tells me I have to stand. Questions?
I actually have one.
Okay.
So if the judge gives them permission to move freely about the court, is there a distance they have to stay away from the jury and the witness?
Okay. You do not want to get close, right? You do not want to get close. So for example, if this was my courtroom, and let's just say the edge of the tables there is the front part of my jury, I'm probably not getting any closer than this. All right, I want to stay, because if I'm like right here, like this is a little more uncomfortable. Right? I mean, because you almost feel like you have to acknowledge my presence right here, right? As opposed to like when I'm back here. Because now, like I'm actually paying attention to you. And it's gonna shut them down, right? But if I'm back here, she's at liberty to kind of drift off, which I have to let them do, okay? But
Sorry.
but it keeps them comfortable, okay? Witnesses, as a general rule, my witness is like this. I only approach when I ask to approach, okay? Only approach when you ask to approach. I don't care if it's your witness or if it's a cross-examination witness. I've got my evidence. Your Honor, may I approach the witness? You may. I'm gonna hand it to her and I'm gonna walk back. I'm not gonna stand. I don't care which side it is. I'm not gonna stand with it. I'm gonna go either closer toward the jury so she can talk to them, or away from the jury so she's talking to me. And then I'm gonna communicate with them, okay? But I'm not gonna be up here. What is this document? Did you draft that? Is that really what you want these? I'm not doing it. Okay? So you want to give your witness plenty of berth and don't get too close to your jury because you don't want to make everybody feel uncomfortable. Questions about that? Man, this is so fun, isn't it? All right. What should the direct examining attorney's demeanor be during questioning? I don't know. You tell me. What should it be?
To the point.
What does that mean?
Cut them off if you need to. But not like quick, but like able to get the point across quickly and to move on to the next question without much of the witness talking.
Okay.
Get them what you want to say. Get them to say what you want them to say.
Okay. Well, isn't that the case with every witness?
Yes.
But like if they like keep going on.
Okay. Let's role play it.
Is this direct examination?
Direct examination.
Okay.
Oh, I thought.
Yeah.
I'm sorry.
Yeah.
Oh,
I'm
okay.
sorry.
Okay. Good.
Cross-examination, I'm so
Can-
sorry.
We can scratch the next step I was going to. Okay, so let's try it again. What should the direct examining attorney's demeanor be?
Okay. The direct examination, they're trying to show the witness at their best and.
What does
as I
that
mentioned
mean?
before, show them as a credible source and as relatable.
How do you do
and
that?
By maybe sharing their background or their academic role or things that would make them look better.
Okay. You ready? What's your name?
Roberto.
Roberto? All right, Roberto, you're up. Let's role play it. You're the attorney. I'm your witness. I don't care what you ask me. Okay, but tell me what kind of witness I am. Am I a police officer? Am I, what am I? Just
Swimmer.
a what?
A swimmer.
A swim.
Billy Bob.
Okay, I'm a swimmer. Your direct examination, I've just been sworn, I'm your witness. Go.
Oh, what is your profession?
I'm a professional swimmer.
Uh,
Look, don't make me feel bad.
Give him credibility, dude.
No, let him roll, let him roll.
credibility.
You want to switch roles?
Yeah.
Good. All right, you've just been sworn. Would you please state your name for the record, please?
I'm Roberto.
Hey, Roberto, what do you do for a living?
I'm a professional swimmer.
Can you explain to the jury what you do as a professional swimmer?
I swim the 400.
Okay, and do you do that for competition?
Yes.
You pretty good at it?
Yes.
Okay. Are you from this area?
Yes.
Okay, very good. When you're not swimming, what do you like to do?
I like to golf.
You like to play golf. You're very sports oriented, aren't you, Roberto? Okay, very good. All right, now we're gonna switch, okay? Ready?
Yes.
What's your name?
Ella.
Ella? Okay, Ella. And on the night that this particular event happened, do you remember where you were?
Yes.
Where were you?
At school.
And what were you doing at school? It's okay. It's okay. It's a special event. And what were you doing at school?
A study hall.
Okay, now, what do you notice about the answers that I'm getting?
They're not very specific.
Well, I might go the opposite direction. They're super specific. Do you remember where you were? Yes. Where were you? School. What were you doing? Study hall. Right? Ask me.
What were you doing at 3 o'clock in the afternoon?
Well, 3 o'clock on that particular day, I was actually at my office. I normally would not be at my office at 3 o'clock because I typically have meetings outside of my office. But on that specific day, I remember it because I had to be at my office. And I had 3 appointments that were kind of stacked back to back. Now, what did I do? I gave more information. All right, guys, listen. When you are a direct witness, I would argue that the attorney's role is right here. The witness's role is right here. Okay? If I'm the attorney, do not make me, what is your name? George. How old are you? 25. Where do you work? The police department. What do you do? I'm a detective. Don't make me do that. Okay? Now, you have to do that within moderation because you don't want your witness to simply be completely narrative, right? What is your name? My name's Josh Crane. I was born in 1976. I moved from Louisiana. Stop. We're not there yet. Okay. And so that's where your attorney has to come in and control that a little bit. And that's going to go to the demeanor of that attorney. On your direct examination, and you'll see this when we contrast it with cross-examination, which is okay, my next question. So watch this. Watch my demeanor. Okay, who have I not? What's your name?
Katie.
Katie? Okay, Katie. I'm direct examination with you, okay? Hey, could you state your name for the jury, please?
My name is Katie Neufeld.
Okay, Ms. Neufeld. And how long have you been a police officer, Ms. Neufeld?
16 years.
Okay, so you've got quite a bit of experience, don't you, Ms. Neufeld?
Sure.
And on this particular night, were you the officer that was called to respond to this incident?
Yes,
And were you dispatched by your central dispatch to get there?
yes.
Okay, you see my demeanor? Now watch. Katie's my police officer. I'm cross-examining her. Ms. Neufeld, you say you were dispatched on that particular night, but in fact, you received a call from a different officer, didn't you?
No.
You didn't?
No.
Okay, so if he testifies that you were actually called by him, not central dispatch, he's lying?
Yes.
See how my demeanor is different? This was a demeanor more of, hey, we're friends, and I want these people over here to be friends with us too. Okay? My other demeanor is more of, it's aggressive, but it's not disrespectful aggressive. Okay? It's challenging aggressive. Right? I'm going to challenge you. I'm going to make you have to answer the questions the way that I want you to answer the questions. And if you don't give me the answer that I think I deserve, I'm going to challenge you on it a little bit, but I'm going to do it in a respectful but firm way. Okay? That's my difference in demeanor. Questions about that? Man, we're so super smart. Okay. Can I hammer the competing team with numerous objections, one after another? As a general rule, no. Okay. Now, will I see that? Yes. Why do I see it? All right. I see it because in your mind, you're thinking objections equal points. Objections equals I'm displaying to the court that I have knowledge. I know what I'm doing. And therefore, they're going to look at me like, wow, they're really on it. Okay. Here's the problem. If every time somebody stands up, who wants to be my objector?
I'm great at doing
All right, good. What's your name? Willis. I'm gonna be asking Willis questions. You just object whenever you want to, okay?
Do I actually have the right like name? Because I'm not good at names.
You mean the rule?
Yeah.
That's the general rule. You better have the rule. If you don't, then I'm gonna get you, but it's okay. Just you just throw them out however. It doesn't matter if they make sense to you.
Okay.
Right? You just throw them out however. Okay, Willis. All right, would you state your name for the record, please?
Willis Patterson.
Okay, Mr. Patterson, what do you do for a living?
Objection, relevance.
Very good. Very good. All right, so watch. All right, ready? Your Honor, respectfully, the relevance is that we need to establish what Willis's background is in order for me to qualify him as an individual that has knowledge about this case. Objection overruled. Thank you. Okay. What do you do for a living?
I am a construction worker.
You're a construction worker? Okay, what kind of construction do you do?
Skyscrapers.
Okay, very good. Do you do work in the Davidson County
Objection,
area?
relevance.
Your Honor, again, I'm trying to lay the foundation of this witness so that we can talk about objection overruled. All right, now what happens the more he does this?
The judge gets annoyed.
The judge gets annoyed, right? If you're the other attorney and you are prepared, it doesn't annoy you,
Mm-hmm.
or at least you don't show it.
Yeah.
Okay? You just calmly deal with it. All right. Now, demeanor, right? Don't take this to the extreme. Okay? But demeanor. If I've got somebody that's objection. Okay, first of all, remember the golden rule that Josh has, right? What do I tell my students? Do not be ill prepared. Okay? Do not be ill prepared. You should be able to look at your course materials, look at a witness statement, and you should, with reasonable accuracy, be able to go, that right there is going to call for an objection. That right there is going to call for an objection. Let me give you an example. I've not seen your problem, but my guess is if I looked at it, I should see these things, right? You're going to have a witness, and somewhere in that witness statement, the witness says, well, I was talking to Frank, and Frank told me ABC.
Hearsay.
Right. Okay. So as the attorney who has that witness, you should be going through that witness statement going, that right there is going to pull a hearsay objection. That right there is going to pull an opinion objection. I mean, whatever. You should be ready for some of those. Okay. So that from a demeanor standpoint, maybe after about the third objection, I simply smile, I pause, Your Honor, the relevance, right? And I'm indicating with some of my body language that this guy over here is a goofball, that I'm in control of this courtroom at this particular time. Okay? So no, do not simply object to object. Now, that being said, if you have reasonable objections, make them. Okay? Again, as a general rule, it's my opinion that if you're going to make objections, you want to know the rule number and you want to state what the objection is. Okay? So, for example, you said objection relevance, right? Perfect. Okay? You could take it one step further. You can say objection relevance, Your Honor. What, I don't know what difference it makes what this witness does for a living, right? So you can say, well, this is kind of why I think it's not relevant. And that kind of signals the judge, and the judge can say, well, what's the relevance? Okay. Okay, so the judge and jury don't receive the case materials and rules prior to trial. That is totally unfortunate. What happens if the judge makes an incorrect decision? You live with it. Yeah. I mean, you can gently try to be like, Judge, you're wrong.
Please don't do that.
And you go, there's this guy that told me to do that. No, that's going to happen because by its nature, they don't have all the knowledge. They don't have, and a lot of times when judges do mock trial, sometimes your judges don't even understand kind of the rules of mock trial. They don't really understand how it works. Okay. So some of it is you can gently educate. Some of it you just have to let it go. It is what it is. Any tips on how to recover from objections not going my way or any unexpected hiccups? Okay, so that's kind of an interesting question, because if you are objected to and the objection is sustained, which means you lose, okay, you really have one of two options. You either simply move on, okay, that's one option, or you address it again. All right, and there's a couple of different ways to address it again. So if I were to ask the question, were you friends with the victim? And he says, of course, go ahead. Objection, right? Objection, relevance. And I say, well, Your Honor, I think it's important for me to establish that my witness was friends with the victim because I think that has bearing on the overall case. And let's say my judge goes, I'm going to sustain the objection. Okay. I've got two options at that point, right? I either go, okay, and I just move to my next question. Or, yeah, this is actually really important to me. And so I say, well, Your Honor, I would respectfully ask for you to reconsider that ruling, because the relevance here is that we anticipate that they will attack my witness's credibility. And my witness's relationship with the victim goes directly to his credibility. Now, the judge still may say, well, I understand what you're saying, but I'm going to sustain the objection. Okay, fine, we move on. Okay, here's another thing. Do this very, very carefully. And when I say carefully, I mean with the right attitude. Okay, we're going to do the same thing again. Ready? What was your relationship to the victim?
Objection, relevance.
Your Honor, respectfully, we believe that his credibility is going to be attacked at some point on cross-examination. We need to establish the relationship between him and the victim so that the jury is fully aware. And my judge says, what?
Sustained.
Sustained, right? So I just lost. All right, so what I do? I go, okay. Is it true that you and the victim were friends? Whoa. See, what I did is I asked the same information a different way. I already lost my first objection, fair enough, but whose job is it to catch me, so to speak, on the second one? It's his. Yeah. He just objected once. Now I have to kind of strategically think, is he really willing to say it one more time right back to back? So I don't ask the same question the same way. I simply change the question. Is it true that the two of you are friends? Now it's out, right? And he's sitting there going, maybe he's going, I thought we just addressed this. I thought this was just handled. But by that point, now I'm 3 questions deep and my information is out, okay? But be careful with that because you want to be respectful. You want to follow the rules. All right, any questions about the attorney stuff before we kind of move to the witnesses. Okay. Witnesses, how do I handle myself on the witness stand? What does that mean? What does it mean?
Maybe don't be distracting.
Okay, don't be distracting. That's good.
Like,
What else?
control your, like, you can't be biased, like, even if you really don't like the person who's on trial, like, in your witness statement, you can't, like, favor an outcome. You have to be unbiased with it.
Okay,
Good posture.
okay. What else?
Answer the questions directly, don't try to, like, extrapolate or go off topic.
Okay, yeah, you definitely don't want to go off topic, especially in mock trial. Okay, how do you handle yourself on the witness stand? We go back to our play analogy, right? You play your role. Get into character, right? That's part of what makes mock trial so fun, and it's part of what makes it so enjoyable for the people that watch it. Get in role, okay? So if I'm your witness and I'm whatever, I mean, do you want, even as the attorney, do you want a witness that comes up, you know, I swear to tell the truth, whole truth, nothing but the truth? Yep. Sit down. What's your name? Joshua. What do you do for a living? Police officer. Were you there that night? Yes. Right? That's kind of, right? What do we want instead? We want, get in that role, right? If you're a police officer, yes. My name is Joshua Crane, I'm a detective with the Mayberry Police Department. Right? You have that little swagger about you because that fits your role. If you're a victim, so to speak, you're more closed off, you're more mild. That's a role to play. Okay. How do you handle yourself? One of the biggest things that I'll see happen in mock trial, which happens in real life too, just so you know, is on cross-examination. Generally, direct examination is a breeze, okay? Because the two of you have practiced and it's like, all right, we got this, everything's going good. But then on cross-examination, the other side's attorney gets up and says, your name isn't really George, is it? You know, whatever, okay? And instead of the person going, yes, my name is George, they go, it most certainly is, George. You know, it's like, well, you're not really a police officer, are you? Well, I guess I am a police officer. And you get this kind of, oh, don't do that. Okay? Don't do that. First of all, understand that if the person that's doing the cross-examination is thinking strategically about this, one of the things that they want to do is they want to knock George out of his character. They want to rattle him. They want to get him moved. Okay? George's not going to do that. So when you cross-examine me, you're like, you said you saw the man throw the rock. You didn't really see anything, did you? I simply go, yes, I did. Well, did you have your glasses on that day? No, I did not. Well, you couldn't have seen. Yeah, I had my contacts in. Okay, it's very calm. Okay, you don't reciprocate their energy. All right. Who do I look at when answering? Oh, we know that. Who do we look at? The judge. Oh. Jury. Sorry. What do I do if I have brain freeze? Okay, the first thing you do if you have brain freeze is quit eating something else. Warm water typically helps. Okay. Brain freeze. It can happen. Take a minute. Don't fall into the trap of thinking that because you are on the stage, you have to be saying something all the time. Pause. Right? I don't talk fast generally, but if you watched me inside of a courtroom, the cadence with which I speak in court is about half of what I'm doing right now with you. My typical cadence inside a courtroom looks more like this. Your Honor, thank you. I represent Mr. Hernandez today. There are going to be 3 issues that we want to present to the, I slow it way down. Okay. That's for 2 reasons. Number one, It's so that my brain, which is moving typically faster than my mouth is anyway, stays in that mode. I want to be thinking ahead. My brain can keep moving, but what's coming out needs to be thought about before it leaves. Okay. And the second reason is if I talk super fast, guess who misses a lot of what I say? The jury and the judge. All right. So I want to articulate. I want to make sure that I make my points. I want to make sure that I'm using inflection in my voice so that I can bring attention to things that are important or not important. Okay. And if you have brain freeze, you stop. Now, don't stop and make it obvious, right? So if you're in the middle of examining someone, or if you're in the middle of making your opening statement, ladies and gentlemen of the jury, this is a case about robbery. No, burglary. Don't do that. Don't do that, right? If you make a mistake, sometimes don't even correct your mistake because sometimes you don't need to correct it, right? Sometimes it doesn't matter that you made that mistake. It's not something that's going to, oh my goodness, the whole thing just fell apart. You just called it robbery and it's really burglary. Oh my goodness, what are we gonna do? Don't worry about it. Okay? So if you say, oh, I'm nervous, and my palms are sweating. Ooh. Okay, he's gonna say, are you ready? I'm gonna stand up and do an opening. Are you ready? Yeah, I'm ready. Stand up. Ladies and gentlemen of the jury, my name is Joshua, and today you're going to hear a case about robbery. My brain is going, robbery, it's not robbery, Josh. It's not robbery. It's murder. Why am I saying robbery? Whatever, okay? I go, but you're going to hear from 3 witnesses. And I moved on, right? I didn't do I don't look at my teammates. Did y'all hear that? I don't do that either. I just flow with it, right? I mean, how many times a day have I messed up? You don't know. I do, but you don't, because I don't broadcast it to you, okay? How do I handle intense, aggressive cross-examination if it occurs? That kind of goes to what we've talked about already. You remain calm, right? You stick to your script, know your script, so to speak, know your role so that they're not able to knock you off. Here's the place, in all the years that I've done my trial, here's the place where I see most people who are witnesses get themselves in a bind, right? The attorney is cross-examining, or even on direct examination, but on cross-examination is like, isn't it true that you said to Mayor so-and-so that you did not know what happened? And she doesn't really know her witness statement. And so what does she do? She goes, no, right? Did I say that? Is that in my statement? No, it's not in your statement. Okay. You have to know your statement. And if you know it, if you're not what? Ill-prepared. If you're not ill-prepared, they won't be able to knock you off those things. And it doesn't matter how aggressive they get, you just smile. Not one of those like, nah, just kind of, no, that's not true. Okay. What should the defendant's demeanor be while on the stand? I don't know. Depends on what kind of defendant he is, right? I mean, I know it's criminal, but I don't know what he's charged with. I mean, that can be really tough. In fact, that's probably one of the toughest things that you do in real life as a trial attorney is making the decision about whether or not to put your client on the witness stand. Okay. I've got a trial that I'm going to start in 2 weeks, March 14th. It's a murder trial. It's going to go for a week long. My client is very, very passive. I mean, if my client was in here today, he would have just been sitting here like this. And if you would have asked him, hey, John Doe, what do you think? I don't know. Right. Sure. Okay, I don't know if that's going to play well in front of a jury. You look kind of brain dead, honestly, right? It all depends on what that role is. Okay, now, as a general rule, it's in my opinion that the defendant, obviously, if you're representing them, you believe that they're not guilty of what they're accused of doing. So if I were dealing with my defendant in a mock trial problem, I would say you need to appear not guilty. Okay? So how do you do that? Well, again, I don't know what the case is, but let's say it's some type of assaultive offense. Okay, he hit somebody or he punched somebody or whatever. Okay, when he gets on the witness stand, you don't want him to be like, "What's your name?" "My name's George." "What do you do for a living, George?" "I just work with my hands." "What I do." I don't want that. Because even if it's true, I want George to be more like, "My name's George. What do you do for a living?" "I work construction." Okay, I want that. And as the defendant, if I am the defendant, I want to keep in mind the same exact things that all of my other witnesses have to keep in mind on cross-examination. "George, you killed him, didn't you?" "By George, I didn't." "You keep on." No, we don't want that. Okay. So as a general rule, if you're the defendant, while you're on the stand, it's a demure, it's a respectful approach. You do not get rattled. And when you're sitting at counsel table with your attorney, if that's how y'all do it, then you don't sit there and look around and snarl at people on the witness stand. And when somebody testifies, you don't go, "Right there's the guard." Hey, don't do that. Okay. Expert witnesses. Expert witnesses honestly can be really, really fun. Okay, because expert witnesses are that one category of witness where I think you can really kind of exaggerate the role, right? So if your expert witness is a doctor, right? Which, "My name is Dr. Crane. What do you do for a living?" "I got my PhD in astrophysics from MIT, and I teach full-time at the university." Right? Okay, did you examine evidence in this case? "I most certainly did." Right? That role can be a little more fun. Now it has to still, obviously stick to your form and build that around whatever that witness is. Okay. Sometimes those witnesses aren't like that. You can have an expert witness that came from the crime. Okay. Bailiff. All right. Whoever is the bailiff is a huge responsibility. Let me tell you something. And I don't care I don't personally care if you remember anything else that I've told you. Remember this. Okay. Go home, fact check me on this. It is a fact. Go get your Bible when you go home and look at the whole body of Christ. And you will be able to find a passage that says, "Oh, but if I am not a hand, I am not of the body." That is not true. "Oh, but if I am not a foot, I am not of the body." That is not true. Okay. Even what are perceived to be the least members are members of the body. The bailiff in mock trial has a huge role. All right. And that is not just in mock trial. That's when I walk into a courtroom, because the bailiff is the person that actually controls the courtroom. Once the judge takes the bench, it's the judge's purview. But before that, it's the bailiff. So the bailiff has a huge responsibility because the bailiff calls the court to order, which needs to be done correctly. And the bailiff typically swears the witnesses, which needs to be done correctly. From a competition standpoint, when we've done competition, and I'll give you an example. I don't remember what year it was, but I coached a homeschool team and we went to the state finals in Nashville that year. When you function at a highly competitive level, the difference between team A and team B is very, it's a slim margin. Okay. So when your judges are determining which team, quote unquote, wins, it's not like a blowout one way or the other. It's a slim margin. Guess who a lot of times can make the difference in that margin? The bailiff. So you don't think that, do you? Because you think, well, the bailiff's not, oh, there's. But watch this. Watch what the difference is. I'm the bailiff. Y'all are my team. Man, y'all been working so hard. I've been sitting over in the corner like, I'm just a bailiff. Okay? I don't get any fun roles, right? And y'all are all pumped up. Y'all are ready to go. It's competition time. Song. You got your little notepads ready. We walk in the court, put our stuff down, we eyeball the other team. No, don't do that. You sit down, right? And then I come in as your bailiff. I go, all rise. Circuit court, wherever county is now in session, all those having business before the court, come before you shut your Huh. You think that's not noticed? Oh, it's noticed. But if my team swaggers in and they look good, they smell good, they got their stuff ready, we finna tear this up. You going home today because you ain't guilty. Or you going to prison today because you are guilty. You want every side of your own. Then your bailiff. All rise. Circuit Court for Williamson County is now in session. All those having business before this court draw for you shall be heard. God bless the state of Tennessee and this honorable court. You may be seated. That's that has some power behind it, right? When that witness comes up, you call your first witness, raise their right hand.
As long as we're tell truth, whole truth, nothing but truth, so help me
You want that? Or do you raise your right hand, please? You solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth. So help you God, no penalties of perjury. Thank you. See, the bailiff has a role, okay? It's been a pet peeve of mine as long as I coached, is nobody wants to be the bailiff. You're smiling at me, which kind of tells me that things haven't changed. Nobody wants to be the bailiff. That's not a cool role. I want to be a lawyer. I want to be this witness. I don't want to be the bailiff. I'm just telling you, the bailiff has an important role. And the bailiff can win it or lose it for you just as easily as an attorney can. Okay, those are all the questions that were given to me. What else do you have?
What are your thoughts on any students that are trying to find loopholes in rules?
What do you mean? What do you mean by loopholes?
Ways to do things they shouldn't.
Don't do it. Don't do it. Here's the thing, and I mean this sincerely. Okay, here's the thing, sincerely. If you think that you will be able to find loopholes in the rules, if you go up against a team that has spent their time with the material that they've been given and they know that material inside and out, your little plan will backfire on you. Okay, it will.
You asked that question last week.
Okay, here's why. You don't need to find loopholes in the rules. Mock trial problems by design are developed to have so much movement within them that there's plenty of things that you can capitalize on within the rules. You don't have to try to skirt them to be sly and show somebody, oh, hey, look, I figured this. Because if you spend your time doing that, I'm going to eat your lunch just doing what I'm supposed to do, right? So that's my opinion. Don't do it. What else?
What about being silly during the trial?
Okay, what do you mean?
Not necessarily taking your role as seriously as you should, either at the attorney table or at the witness stand.
Not wise. Not wise at all. This is the way you have to think about this. I really believe this. I really, really do. If I coached you in a private team, I would require you to function the same way that I function inside a courtroom. Okay? Exactly the same way. You will have the same respect that I have when I walk into the courtroom. You will have the same overall demeanor that I have when I walk into a courtroom. Because once you walk into that courtroom, think about it like this. I don't know any of you. I don't know your backgrounds. Okay? Let's say Sunday morning, some of you, all of you maybe, get up to go to church services somewhere. Okay? You're sitting in church services, the preacher gets up. How many of you are going to start cracking jokes right there? I mean, I hope none of them, right? Why?
Be respectful.
Be respectful. That environment is not the time for that. Right? That's not the time for that. Now, there are plenty of times where if you watch court, when the judge is off the bench and the attorneys are just talking and we're trying to get things done, I might be like, hey, man, I saw you the other day going down the road and you had that dog chasing you, man, that was funny, or whatever, right? But as soon as the bailiff comes in and says, all rise, we're back to business. Okay? So if you're sitting at your table or if you're on the witness stand, don't be goofy. And if I was your coach and I saw you doing that, I would get on to you because I would say, here's the thing. You have permission from me to be silly and goofy once you know your problem so well that nobody can compete with you. But you don't know your problem that well. So you don't have time to do those other things. I know it's tempting, isn't it? What else? Hit me.
Can like only one attorney call the objections or can multiple?
You'll have to look at your rules. The way the rules worked when I did it was the attorney who was doing the examination or direct or cross-examination had to be the attorney that called the objection, but you'll have to look at your specific
Or
rules.
different.
Okay,
I'll go over that.
okay. What else?
Yeah, sure.
Like, in our specific mock trial rules, there's nothing about like if a cross-examination attorney is harassing the witness. Is there anything you can do if that happens? Like, there's no objection in the rules, but is there anything you can
There's
do?
no
Like,
objection for that.
like to protect your witness if like the cross-ex attorney is harassing them or badgering them?
Okay, again, I haven't seen your particular rules. Normally, there is an objection for badgering the witness. There's not for you.
There's nothing we can do.
There is something. I have to be careful because I don't want to tell you to do something that's not in your rules. So if I say something that's not in the rules, y'all just correct me later. This is the way that I would handle that, okay? So he's my witness, and I've sat down, and now he's cross-examining. So start cross-examining and get to the point where you're badgering him. And watch
Did
what
you
I
not see the murder take place? Did you not see the murderer enter the building?
No.
You went into the building, didn't you?
Yes.
The building was red, wasn't it?
Yes.
The building was on 4th Street, wasn't it?
No.
Okay, stop. All right, so right now, this is beautiful. This is really this is so much fun for me. First of all, you're not leading. Okay.
Oh, man.
And second of all, you're not badgering, right? So I'm just gonna sit and let you roll. Because what you're doing right now, you're asking direct questions. You have a cross tone, but it's really a direct question. Ask those same questions, but lead him this time.
Cool. The building was red that you entered, wasn't it?
Yes.
Was it on 4th? It was on 4th Street.
No.
You did enter the building, correct?
Yes.
The door handle was made of brass, wasn't it?
No.
You saw the murder go inside, didn't you?
Yes.
Why did you follow the murderer?
Because I'm scared.
Okay,
Did
stop.
you take?
Now watch. See, oh, this is so fun. I love this so much. Okay. This is so cool because he's having a hard time badgering you. Right? It's hard. Isn't it? It's not, I mean, you think in your mind like somebody's gonna get up and like, you're gonna badger my witness. So you ain't badgering nothing. Right? He's just answering your questions, right? Okay, watch badgering. Okay. You saw the murderer that day, didn't you?
Yes.
And you actually followed the murderer from the building, did you not?
I did not.
Yes, you did. And you did that because you wanted to find out where he was going. Isn't that true?
No.
It absolutely is true. Now I'm badgering. Okay? Think of badgering like I'm arguing with my witness.
Ooh.
Okay? Because remember, on cross-examination, that's a liberal approach. I mean, you have to lead. And it's going to be a little bit more direct and aggressive. Okay? But badgering gets to the point where that is not true. You know, okay, now I'm arguing with it, right? Try that and watch what I did.
You did enter the building on 4th Street, didn't you?
No.
Yes, you did. It says so in your witness.
Judge, objection. I ask that you direct counsel to allow my witness to answer the question. Now, what have I done? What's the first thing I did that was most important?
Oh, you stopped him from badgering. You kind of cut
I
off.
stopped you.
Mhm.
That's the first thing I did that was important, right? Because whether the judge tells me at that point, well, Mr. Crane, this is cross-examination, he can ask, I don't care. Because my goal was to stop you. And when I said objection, you stopped. Now, if I don't have a rule that says, objection badgering the witness, I'll say, objection, judge. I would ask that you advise counsel to let my witness answer the question fully before he asks the next question. Now I sit back down and guess what? You're now starting from zero again. Okay, because I just took your momentum away.
Okay.
Does that help you?
Yes.
Okay.
Thank you.
What else?
So like, you're able to ask like yes or no questions in direct examination?
Yes.
What is so what would the difference be for a cross?
Okay.
Then
Okay, good question. All right, so direct examination are direct questions where you do not lead the witness to an answer. Okay, so a direct question is, what is your name? Okay. Adam, what do you like to do for fun?
I like to bowl.
Okay. Are you pretty good at bowling?
Yes.
Okay. Do you bowl every week?
Yes, I do.
Okay. Do you bowl in a league?
No.
Okay. On September 3rd, 2021, do you remember where you were?
Yes.
Where were you?
I was in bowling.
Okay, and you see, all my questions are. Do you live in a bowling alley?
Yes.
Yes. Okay. But you see,
I am.
this is super important for you to understand for when you formulate your questions. Were all of my questions yes, no questions? No. Okay. But all of my questions asked for specific information, and he's allowed to give that information. And that information does not have to be yes, no, yes, no, right, left, up. It doesn't have to be that. It can be narrative. Now, watch a leading question. Your name is Adam, isn't it?
Yes.
How was that a leading question? You still said yes, but how is it a leading question?
And like, isn't it? You added like.
What did that question contain that my other questions did not contain?
It like, wouldn't it be, I guess, a good answer if you didn't say yes or no?
Instead.
What did it contain?
You were kind of more stating, like saying, that's your name, isn't it, rather than asking.
Okay, I'm gonna keep working with you. What did that question have that the other questions did not have? What did it contain? Okay, what did it contain?
Instead of saying from the direct examination, giving an open-ended question, you're saying a fact isn't that right?
Okay, you're explaining it. What did that question contain that the other question? What?
Contain the answer.
The answer to the question. There we go. That's what we're looking for. It contained the answer to the question. Your name is Adam, isn't it? Adam's the answer. And you went into the building, didn't you? That's the answer. You see, I'm giving him the answers. On my direct examination, you have to give me the answers. Okay? Make sense? All right, good. What else? Nothing? This is so fun. Anything else at all? Anything that you struggle with? Anything that you're not crystal clear on? Yes.
Well, it says mock trial is like a play, right? And so you're sort of acting like the role, but it also like, or we say don't overact.
Mhm.
So what extent would that be? Like,
Well, there's a difference between drama and melodrama. Okay. So for example, if I go home today and my daughter comes up to me and says, she's got tears in her eyes, okay, and she goes, Dad, the goldfish died. Okay, is that drama or melodrama? It's drama. Okay, I come home, my daughter comes to me with tears in her eyes. Dad, the goldfish died. What is that, drama or melodrama? Okay, there's the difference. You play the role, don't overplay the role. And that can be tricky, witnesses, whoever you are, that can be tricky because you've not done this before. And so you don't have a meter kind of built in where you're like, I think this is enough, right? So you kind of have to feel that based on whoever you are as a witness. If it feels like it's too much, it probably is. Okay. What else?
For if we are cross-examining a witness, what is kind of the line on being like aggressive or cutting people off with your questions? Because again, if you're saying you do too much, you will get like an objection for that.
That's kind of like the drama melodrama. There's a line, okay? And I understand for mock trial purposes, you're going to feel like if I'm going to cross-examine, it needs to look different than direct examine. I understand you feel that, okay? I can tell you that even in mock trial, if I were coaching you, I would coach you not to be aggressive. Okay, and when I say aggressive, I mean that's not like your primary mode. Okay, but that's because, and I don't know if you can tell me this or not. Do y'all do openings and closings?
Yes.
Okay, that's strategic. All right. Let me kind of give you an example of why. If I'm cross-examining somebody, right? We've already established that cross-examination questions contain what?
Answer.
They contain the answer. All right. So I already know what I want that person to say. So think about it like this. If I cross-examine somebody, am I cross-examining them to get information? No. Why am I cross-examining?
To discredit them?
Maybe.
To confirm the answer to what you already know.
Okay. I'm cross-examining people to get them to confirm my information and to potentially negate the information they gave on direct. That's what I'm doing. Okay. So if I cross-examine somebody strategically, the way that I think about it is, how much do I benefit by going, what was your name again? Willis. How much benefit do I have by going to Willis and be like, Willis, you were there that day, weren't you? Yes. And you're the one that pulled the trigger, aren't you? Okay. Wow, man, he's really laying into Willis, right? And now you might think, okay, yeah, that's good. That's good cross-examination. All right, but here's my thought. I go to Willis on cross-examination and say, Willis, the fact of the matter is, you were there when this crime was committed, were you not? And in fact, you pulled the trigger, didn't you, Willis? Okay. You want the jury to believe that you didn't pull the trigger, but you did, didn't you, Willis? I just worked you in a circle. Now what happens? I haven't beat him up. I haven't rah, right? But then when I go to my closing argument, I'm like, ladies and gentlemen, you heard Willis. You heard what he said. At first, he said he wasn't the trigger man, but then what did he say? He said, in fact, he was, right? So balance how aggressive you are with your cross-examination witness with what you're going to want to tell the jury on your closing argument. And don't just focus on how aggressive can I be? Because if you focus on that, you might actually lose the details of the statement that you really want to get home. What else?
If
Would it help if you stood up in front of everybody?
Oh, okay, so if you like asked a direct question and the witnesses are like talking, and if you need to cut them off,
Okay.
how would you?
Sure. Okay, let's do it. All right. On that particular day, do you remember what you were doing?
Oh, yes, I was in the bowling alley, and so I was about to leave, and at the
Okay,
time-
so you said you were in the bowling alley? Okay, do you remember what time you got there?
6:30 a.m.
You see what happened? So I don't necessarily have to say, hey, stop, right? I just, okay, so you were in the bowling, and when I start talking, you naturally, okay, now I'm listening to you, okay? But that's also important, like on your direct, that should never happen because you should be in sync with your witness. Witnesses and lawyers need to be in sync. Cross-examination, that might happen more, but here's, oh, this would be so fun. Watch this. So what happens is like the reverse of badgering, right? Remember the badgering? Well, what happens when it's the lawyer that's getting badgered, right? What happens when it's, I cross-examine and go, you were at the bowling alley that day, weren't you? Now just go off on whatever.
Well, yes, and also while I was at the bowling alley, I was.
Okay, but I'm not asking you what you did at the bowling alley. I'm just asking you, you were at the bowling alley, weren't you? Do it again.
Yes, and also as I was at the
Okay,
bowling.
Your Honor, I would ask that you instruct the witness just to answer. You see what's happening? It's the same idea, okay? But to answer your question, you have to insert yourself. But insert yourself, not by like, hush. You know, cease speaking. Right? Just go, so you were at the bowling. All right, now I brought you back to my point, right? Because this is I control this, not you. Got it? Awesome. What else?
We don't have any rules or much on the book about how long a witness can question, or I'm sorry, a lawyer can question a witness. But can we get objections if you go too long? Like,
Do y'all not have time limit rules
No.
per side? Okay. Okay, if there's no time limit rules, then no, I mean, you can ask. However, you still have a finite amount of information, right? So what you don't want to do is you don't want to cover your information and then recover your information and then recover your information. Okay? Just cover your information. If that takes you 20 questions, it takes 20 questions. If it takes 5, it takes 5, whatever it is. But don't artificially prolong it just to be on your feet. What else? I don't time y'all have to go to your next thing.
Oh,
So
we're good. I'll just, gonna let you roll as long as you need to. We can cut that short today. It's fine. Any other? Okay, well, if you think of any, throw them at me and I will see if Mr. Crane would answer
Thank you
those.
so much.
thank you.
Yeah, thank you so much.
Thank you.
Yes,
All right, y'all have fun.
all right,
What's next, Matt?
now.
I should ask more questions.
wait.
Yes, I'll show you.
Read
Circle
that.
of sun.
Circle of sun.
Besides the list, it makes it
Like,
Wait, what? That's more, I know.
Okay, Roberto, we're making a new Broadway musical. It's like Lion King, but it's the Sussy King. The Circle of Sun.
Yeah, I have it.
The Circle of Sus.
Circle of super such.
And Jack, you were the one standing in the circle on stage.
On the circle. I am
What
the Circle of Sun.
It's waxed.
What?
It's like
I bet
gum.
It does. Jack, how many bagels did you have?
Yeah, two.
Bagels.
Two.
Bagels.
Two.
I love the bagels.
Is that overly excessive?
Yeah.
Thank you.
Don't trade for a bunch of.
Hey, will someone please pass me my hat?
I sent you a packet for your packet.
You just have
No,
to-
actually, you can take it, like, just eat that.
Guys, this is a new fashion. This is a new fashion statement. This is a new word. This is a new
I'm
fashion.
wearing that shirt. It's like
This is my third year doing this. That was the best attorney
That was
I've ever
so
seen.
good.
Let's go.
He did such a great job.
It's so good.
Do you need anyone?
He was funny too. Yeah. Oh, my hair. Oh, boy.
How do you guys feel now?
Unless it has.
My hair.
Questions come up along the way.
I have a question.
Okay,
Not kidding.
well, I mean, like, math is kind of toast.
Yeah.
So, but I mean,
Yeah.
like, we'll try to
Yeah.
I had it really easy. So, while my brain is
Bruh.
on it, Adam, you asked him a question, and I think, because he's like, you have to check your rules. Do you remember, it was something about objections maybe?
No.
Do you remember what you asked him?
Like how to stop the
Go back.
witness, like they keep asking.
Badgering?
No, it's about punching the stand. Was it about punching the stand?
Oh, I can't remember what it was. There was something that he's like, I don't know your rules and you'll have to check them.
And then.
And I can't remember the question. If you think of it, let me know because I think I need to address it per our rules.
Did I ask you, was that what I?
Oh, I remember this, yes, and you were like, no, I'll go over this, yes, I remember.
Yeah,
this
and I'm like,
question. I don't know.
I can't remember it. Okay.
No.
So, anyway, you will be doing,
What was it I asked you?
I'm
What
sorry.
was it that I asked you halfway through?
Dang.
Oh, something about,
Funny.
I'm sorry, what's it?
My wife, you can take it. Sorry, wife.
what did you say? About
I can't remember, but then I asked you and you're like, no, we can't do that.
It was something with direct examination.
No, it's not.
Okay. It'll come, I'm sure it'll come back.
Oh, yeah, on cross examination, we can't. No, on direct examination, we cannot ask leading questions.
That is
That's what
correct.
he did. Yeah.
So he did ask a leading question during direct. That might be real life,
Yeah.
and it might be even mock trials that he's done before. Our rules are kind of different. So you can ask yes or no questions during direct. They just can't be leading.
What is the
questions.
difference between direct examine yes or no questions and cross examination?
So direct examination questions with a yes or no answer, it's just like,
Where you got the ball?
yeah, where you got the bowling alley. That's something that you can do for direct. But you can't, for direct, say, you were at the bowling alley. You can't do that. And I think he did one during direct, so just make sure you don't ask any leading questions during direct. Those are all-
Start sleeping.
Okay, so, oh my goodness, like, it'll be okay. I think that,
If we're doing that, I would be quickest problem.
Bro, I was
Yeah,
gonna
they
give
have
the
the
fashion
fashion
question.
so you know that this week you're doing any charts for state statutes, right?
Yeah.
Okay,
Wait, were we supposed to do any?
What is the state statute?
well,
I
I
mean,
mean, like, I'll bring these
What?
questions for these, yes.
Did you?
It's not in the guide.
What is the
It doesn't
state
say, they just
statute?
have to end up.
That was
I feel
So
real
here's
stupid.
the deal, with
Yeah,
any,
mine's
can you guys hear me? With any semester long team group project like this, there's stuff that's just gotta be done, that's not necessarily a specifically listed guide assignment. And creating direct and cross-examination questions for the exhibits is one of those things. So you did the Annie for a reason, questions do need to be created. So I will take what is on these Annies. I'll bring them to Nyla's if anybody has anything to add to them, that's fine. And I will see if I can create a Google Doc for these, if that makes, just for reference purposes, really. I mean, I don't think you have to do anything necessarily with them. If you're like, oh, what did that say? And you can go look it up. But you do need to do direct and cross questions for the evidence. Yes, ma'am, I think you do.
What are state statutes?
Yes.
Okay, so let me get there. In your mock trial notebook,
It has to say something about spoiler laws, it's better than something.
No, it doesn't.
I got
So sad.
Yeah.
Like, who would have assumed that like going on someone's property is just not?
Are you one of the
Yeah,
Fullertons or
Like,
something?
wouldn't you just
Yeah.
assume it was illegal? Cause like, we don't know that. It's like, but we can't assume
Okay.
that it could be illegal.
if you have your mock trial notebook
I mean,
with
you assume that we.
open it up,
Yeah, you have to make
guys,
sense.
and then Roberta. I
Okay,
think
so what
I'll
page?
Page 40.
Question I was gonna ask is if it's on Google Docs, can I take my Annie chart, I left mine at home, can I take my Annies and put them onto the Google Docs, like my
What
phone?
do you say?
Once I get them on there, then yeah, sure, you can add your stuff. But it's just, basically the Annie would be for reference purposes while you're creating questions. Oh, I can't remember what that said, or I don't know what so-and-so put on the class Annie, and I'd like to see what's there. It would basically be for reference purposes. So on page 40 and 41, you see applicable law, Pennsylvania state statute. Okay?
Yeah, that's the only thing you only have to do on Annie for this.
Let me double check. but I don't want to steer you wrong. Poor baby.
I know.
Yeah.
Poor baby. Is Alyssa?
That was.
Oh, is she still going? Oh, sorry, Alyssa. I'll get it in a second.
She's not even here. She's not here.
She is.
Oh, she's there. It's
Oh.
right there.
Where did she go?
I
She
would say
fell.
hi, but.
She fell.
Write a short summary for the state statute and each of the judicial decisions. Prepare an chart for the statute and judicial decisions to determine
Each one.
if each can be used to prove or disprove evidence or witnesses' testimony.
You would write an Annie
So-
for each one, each whole paragraph?
But I mean, they're kind of little. It's a short summary and then an Annie.
Wait,
So
how do we
Annie-
summarize? Driver did not manifest extreme indifference to human life when he was intoxicated and ran a red light, striking and seriously injuring pedestrians.
Oh,
Driver did not
For that?
manifest extreme indifference.
So here's the deal. Can that put Dilius in jail or keep him out? Like that, do you get what I'm saying? Like, so let's see here. Let's look at the Commonwealth versus DeStefano. That's further down on the page. Pennsylvania Criminal Code defines third-degree murder as any killing with malice that is not first or second-degree murder, generally with all the alphabet soup. Decisional precedent further establishes that third-degree murder requires no specific intent to kill. So can that be used to put Zilius in jail or to keep him out? So do you see how your Annies are gonna be short?
Yeah.
Wait, so we have to
So,
make
like,
an
it's
Annie for
just-
each individual paragraph?
I mean,
What can just an Annie for the whole one?
so there would be an Annie for the statutes.
Applicable statute.
Yeah.
And
And
then
then there would be an Annie for judicial decisions. You would probably have to do an Annie for
Each one.
each one. Yes.
Okay.
Does that make sense?
Is this in the guide, or is this one that's not in the guide?
This is in the guide.
What
This
is not in
your-
the guide?
making the questions for the evidence.
Do we have to do that this week, Nick? Like,
I'm writing that down.
Just however they get in there, once you get roles and you're working with a specific witness statement, let's say that the people who are working with Micah, like that mini team would look at any evidence that pertains to Micah's statement and create cross or direct examination questions.
So do we
That-
have to practice this week, or just doing this with?
I
our
would get
team?
your questions taken care of first.
Questions for
Like
evidence?
your questions for your evidence and then also this. So let's say person A, B, and C. A's Micah, B's the direct examining attorney for Micah, C's the cross-examining attorney for Micah. They're a little mini team. So they would go to Micah's They would go to Micah's direct examination questions on Google Docs and cross-examination questions on Google Docs. And they would fix anything that needs to be fixed first, because you can't practice until these are further
Are we
refined.
gonna have those sheets, the hard copy of those sheets with somebody on a team?
So that's up to you as far as like if you want to print them out or if you just want to deal with them on digitally on a laptop or whatever.
We could do it like on Fridays, like. on the same-
Oh, right, like if you want, well, that's up to, so you will have some time to practice at Nyla's, hopefully. But until all of these tasks get completed, it will only be part of the time, depending on what we get taken care of in class. Does that make sense?
I'm just looking at how we're gonna get that done. Those questions that you showed,
Mhm.
those questions done on digitally with our team.
Well, I'm saying it can either be digitally, like over Zoom with a shared Google
Oh.
Doc,
Okay,
or you can meet in person and the three of you sit around and you have a typist.
yeah.
But you would need to work that, so these, and then questions for these, your little mini teams are gonna start figuring that out. Does that make sense?
Yes.
Yes.
So I don't remember, it said like somewhere we might wanna have clean copies of the witness statements.
Yes, I will provide all of that for you guys, that's later on. further down the road when you're practicing, this thing is full. Like I still have them from, like I had extras from last year and I just kept them. So, and I'll probably be making more copies. There will be paper everywhere. Because I will hand whoever is dealing with the crane specs that, I will hand whoever is dealing with trench warfare, they will get that. I will send it to you digitally and you can make your own copies if you need them. So, you will have the evidence like I just have it in here. So that will be made available to you and you will need them for trial day. So that's why I send them to you digitally, is because you know which pieces of evidence you want to use for your witness. And so you're going to need clean copies, because let's say you're an attorney for Micah and he loses his place or she loses her place, and you grab a clean copy of the witness statement, you find the line, you highlight it, you submit it into evidence, and you say, can you please read from your witness statement? That's why you need the clean copies. Does that make sense?
I have a question. Can we like meet with the other team and do like practice trials
Yeah.
against them?
Yeah.
Not the
Yeah.
competing team. no.
That it
It's
is
just-
legal. It is legal.
Wait,
It is legal.
So we do a dress rehearsrsal. I've done one both years. But,
with
and
the
you can
opposing
practice with another class, but not the class you're competing against.
team. What?
There are people that do that. Now, we've only ever just run the trial, switch and practice that
I
way.
would say another class, you mean somebody else who's doing.
Another B that we're not competing against. That's the only way, but you're not going to want to practice with the team you're competing against. That's, bad juju right there. But like say there's a third challenge B, it's like, we need a dress rehearsal and we want a team to run a dress rehearsal with. I would ask your families, hey, is everybody available on yada yada day at yada yada time? And can we do this dress rehearsal?
Yes.
And if it works for everybody, then absolutely. Does that make sense?
Yes.
Is a dress rehearsal basically the whole trial practice?
Yes, you come in it doesn't have to be the exact outfit you're going to wear. It can be something very similar, but typically a day or two or three or however it works out schedule wise before the trial, you come in dressed as your part and we roll like it's the real thing with no stops.
We should do like class.
Does that make
mini
sense?
Trials.
Okay.
Gosh.
Yeah, match is just text today. That's okay. All right. Hey, Alyssa, could you see and hear everything okay?
Yes, I could.
Okay, I hopefully recorded this and I will send it out to everybody's parents. Thank you.
Hi. Miss Sherry,
Yes,
I have a question.
okay.
Will you give the envelope to my mom, or will you just wait until next week?
Oh, I'll hand it to your mom. You can find out today.
Okay. Thank you.
Yeah, I've already talked to her. Okay.
Thank
All
you.
right, everybody, don't spill the beans for Alyssa, okay? All right, okay. Thank you, bye.
Yes.
There's